Hey everybody, it's Tyler Flood, Houston, Texas DWI defense attorney, and we are back again live at our regular Friday 2 o'clock web chat. I'm here answering all questions DWI, so this is for anybody who's out there and has questions that they're dealing with on their case. If you're an attorney, this is the time I'm making myself available for a half an hour or more to answer any questions that you have that you might be struggling with, or strategy questions, or just general questions about DWI. So today we thought that we would focus on like the top 10 questions that I get asked about DWI from other lawyers. DWI has become such a specialized area that really you can't do general criminal practice. You can't do general criminal cases anymore and expect to be an expert or proficient in handling DWI cases because they've become very complex. I have some of my colleagues who are much more senior, and they make no secret that they feel that blood draw DWI cases are some of the most complex criminal cases in the courthouse, rival with even DNA cases or murder cases or things like that. So anyway, with that being said, I'm going to go to the questions and answers, and let's see if we've got anything so far. Okay, how do you should you, let's select this one first. Should you handle ALR hearings, and how do you handle them? Definitely the answer is yes, you should always handle your own ALR hearings. ALR stands for Administrative License Revocation, and this is the hearing that you are able to request within 15 days from the date of the arrest for a DWI. So there's no automatic license suspension. Many people that come in to meet with me are worried that their license will automatically be suspended because they refuse to take a breath test or refuse to blood test. Nothing could be further from the truth. There is no such thing as an automatic license suspension. I've even heard people call it automatic license revocation. Well, it's they certainly can be fought and won. And by winning, I mean obtaining a dismissal or winning on the merits and saving your client's license from being suspended. The way that you do this is hopefully the client comes in and hires you within the 15 days, and you send a request to DPS in Austin notifying them that you want a hearing and it requires certain information to be included in the request, or DPS will automatically deny your request and you won't get a hearing. So pay attention to the rules. The forms are right online on the DPS website. Then you sit back and you wait for about a month or so, and you'll get a notice of hearing in the mail from DPS, and it will notify you of the time and place of the hearing. At that point, important deadlines start to kick in, and you need to send over a discovery request to DPS and request all the documents that they plan on using at the hearing right away. You also, once you receive the discovery back from DPS, then the job's not done. You then need to go through the two-part analysis for any ALR hearing. And you need to have a talk with your clients too. You want to say and find out beforehand, is the most important thing to try to win the license hearing and save your driver's license? Or are we going to use this more for an opportunity to gain some free discovery with the officers on the record in an attempt to help us fight the DWI case going on in court? Different cases require different strategies. If it's a first offense DWI and your client is more concerned about their driver's license, then you want to win the hearing and have save the license from being suspended. We're handling a case right now that's an intoxication manslaughter, and in this case, we know that we could probably win the license hearing because there's a fatal flaw on the DPS's paperwork. But if we don't subpoena the officers, we miss out on the opportunity to question them all about the causation about this accident, and the causation is very important in this case. So we had a talk with our client. We said, look, we can win the license hearing. I know we can, but I think it's important that we subpoena the officers to be there. And if they show up, let's use that as an opportunity to learn as much as we can about the causation in this intoxication manslaughter before it goes to trial. And he agreed with my advice that, you know, the judge has already ordered him to not drive anyway, so we're going to subpoena the officers, and hopefully they'll show up and we can question them. But so let me take a step back. Any attorney that advises you that an ALR hearing is a waste of time, I would get up and walk out of that lawyer's office. They obviously don't understand the importance of a license hearing and how it can help your DWI case. They don't understand how to win them. And they obviously, that's a telltale sign that that is not a DWI specialist that you are dealing with. If they say that, oh yes, we do all of our own ALR hearings, we do them telephonically. Again, stand up and walk out and say thank you for meeting with me, but go hire somebody else. You will hardly ever win a license hearing doing it telephonically. And by telephonically, I mean that there's a provision in the code or the rules that allow you to host an ALR hearing over the phone with the officer, but the officer will always be available because he will always have his cell phone on, and he will always appear telephonically, and your chances of winning based on having it dismissed for the officer not showing up is going to be about zero. So the two-part test to determining what you do, as a matter of fact, here comes our ALR subpoena guru right here, Mr. Roy Diaz. So, hey, Roy.
How you doing, sir?
Out serving some ALR subpoenas?
Yes, sir.
Okay. We're doing our Friday web chat right here about ALRs.
Okay, great.
So, that's the ALR wheels in motion right there. So the two-part test is you look at the paperwork that DPS sends you, and you look at it and you say, okay, if we did not subpoena any officers, can DPS make their case? And if the answer to that is yes, then you look to see how many officers you can subpoena. And the rules say that you're allowed to subpoena up to 2 officers and more for good cause, but upon approval from the administrative law judge. 1 officer for that made the determination of reasonable suspicion, like they're the officer that did the traffic stop, and then another officer came out and actually did the field sobriety test. That would be the probable cause officer. So if you have that situation where there's 1 stopping officer and 1 probable cause officer, you get to subpoena those 2 officers automatically. And if one of them doesn't show up, you object to the paperwork coming into evidence, and you will get a negative finding, which means that you win. Your client's license is not suspended. Sometimes, even if they do show up, you can question them on the record and attack the merits of the case and still obtain a negative finding, but it's much more difficult. So for an example of a paper case, which is what we kind of refer to it, if you're not subpoenaing any officers because you feel there's a fatal defect with their paperwork, then that's referred to as the paper case. And an example of one would be where the reasonable suspicion or the probable cause merely states major crash. That's all that the document says. Well, that's insufficient to prove probable cause. It doesn't show really that your client was even operating a motor vehicle, how they were involved with the crash, or that there was any probable cause to suspect that they have done anything illegal. If it just says a word like major crash or involved in accident, that could be, you could be involved in an accident as a passenger, or involved as an accident in an accident as a bystander. So those are the kind of things you look for. You always want to handle your own ALR hearings, and sometimes that can be the difference between a dismissal on a DWI and not. when the officer shows up at the ALR hearing, that's the perfect time to go through all of the sobriety tests and any evidence that they have and question them about how they administer the field sobriety test. You can get some great testimony from officers who aren't very proficient on the administration of the HGN. Remember, when these officers show up to the license hearing, they're not prepared like they would be if they were going to trial. They've just gotten off a long shift the night before. They come in, they probably haven't even watched the video or looked at the offense report. And if you're prepared and you're on top of the case, you can go through and score some points on the record and do some damage to their DWI at the ALR hearing before it ever would go to trial. And we can talk more about that on another time. Okay, let's do this one. What is a 15-minute observation period, and how do you prove that they didn't? How do you prove there's a 15-minute observation period problem? Well, a 15-minute observation period is the statutorily required time period that officers, actually not an officer, a certified breath test operator must observe you in their presence before you blow onto the Intoxilizer 5000. And the reason is to ensure that you don't put anything in your mouth or do anything that would cause mouth alcohol to skew the BAC result and create a higher BAC than it normally would be. So you're not supposed to smoke, chew gum. If a person coughs, vomits, puts anything in their mouth. We had a client one time that had chewing tobacco in his mouth when he took a breath test. But the purpose of the 15-minute observation period is to make sure that a person doesn't put anything in their mouth for 15 minutes. So officers will always state that they did do the 15-minute observation period, and it's very hard to disprove that. So there was a case that just happened this week by one of my colleagues who did an excellent job. We've done this before, but now we're able to obtain jail surveillance video, and the prosecutors don't get it. So the officer was on the stand and said he did the 15-minute observation period, but we looked at the times from his car when he said that he arrived at the station, and then looked at the time of the test slip, and then we showed that the time that, well, in our case, we showed the time from where he was to the time the breath test happened. There's no way there could have been 15 minutes between the two. In this case that just happened last week, it was the video from the jail surveillance showed the officer leaving the person's presence during that 15-minute period. And he went up to the officer on the stand and he said, "You're lying to these people, aren't you?" And his eyes got real big. And that attorney did prove that the officer was lying and he did not perform the 15-minute observation period. I'm not sure why the judge did not suppress that, because this is statutorily required, but the jury did the right thing and found the client not guilty. So it's difficult to prove 15-minute observation period violations, but with enough work and investigation, it can be done. You've got to get the MDTs, which are the mobile data terminal communications from the officer's car. You've got to get the breath test slip, obviously, and get all your breath test discovery. Sometimes you find breath test slips from another person who was right in front of your client, and it might have been the same breath test operator, and it might show that they were done within 15 minutes of each other. So more than one officer can combine on the 15-minute observation period, but they all have to be certified breath test operators. All right, let's talk about how do you feel about adding D's? What is that? We have an Atticus Finch.
Sobriety test?
It's whoever Atticus Finch is. If you could resubmit that. How do you feel about adding D's as one of the SFST? I don't know what D's is. Anyway, Why are lab witnesses now extrapolating with almost none of the proper extrapolation facts? Let's answer that question. That's really good. So the case Mata v. State, MATA, I'm not sure what the citation is, but it's still the seminal case regarding the variables required to do a proper extrapolation. When we talk about extrapolation, that's obviously when you're convicting a person of DWI on a .08 theory, the only time that matters is the time of driving. So you always have a BAC level at some point later in time. It's up to the state to prove beyond a reasonable doubt what the BAC was at the time of driving, that it was a .08 or over. So there's a method called retrograde extrapolation, and it's a fancy word for just basically back calculating. They use different formulas. One is called the Widmark equation. But if you know certain variables, you're able to calculate with some reasonable amount of reliability what the BAC would have been at the time of driving. But so Mata is becoming increasingly ignored in the courts, and definitely by the Houston Crime Lab, thanks to one Mr. William B. Arnold. And now he's training his lab technicians that you don't even need the time of the last drink. Well, actually what you need is the time of the first drink, the time of the last drink, the number of drinks, the time the person ate, the person's weight, whether they're male or female, the size of the drinks, the alcohol content of the drinks. And that has become eroded over the years. When I first started doing this, no judge would let you extrapolate unless you had all those facts. And Mata is a very good read. It contains the laundry list of facts that are needed for a reliable retrograde extrapolation. And it cites many of the world's foremost experts in the way alcohol affects the human body, including Dr. A.W. Jones. And they all warn that retrograde extrapolation is a dubious practice and to approach it with extreme caution. So along the way, the variables that have been required have been slowly getting knocked out one by one. And it's come down to the point where most of the lab employees will say, I don't even need to have the time of the first drink. I don't need to know how long of a time period they've been drinking over. I don't need to know how much they've had to drink. I don't need to know when they ate. I don't need to know their weight. All I need to know is the time of the last drink. And we fight this very hard, and most judges will not allow them to extrapolate with just the last drink. If they do, then we go through on cross and we just count and write down on a pad how many assumptions they're having to make that they don't know anything about in order to get to that number, and that it's all speculation and assumption. So in a case we had this week, the newest member of the Will Arnold team came up and said, well, here's what I'd like to have. Time of first drink, time of last drink, but I would like to have the time of the last drink, but I really don't need to. And she's basing this on no scientific research. She's basing this on the fact that her boss told her that when you take that stand, you don't need the time of the last drink. Just say that the best estimate of what the BAC level was for the time of driving was whatever the BAC level was at the time of the test, as long as it's within 2 hours, or if it's 2 hours after the time of driving. Well, we happen to have a situation where it was 2 hours after the time of driving, but the analyst also said that a person can still be absorbing, going up in their BAC level for up to 2 hours. So if you have a 0.14 BAC 2 hours after driving, and they can still be absorbing for 2 hours, then there's no way that an expert can say they weren't below a 0.08 at the time of driving. As soon as this expert started to offer this completely speculative opinion with none of the required facts, for valid and reliable scientific evidence, the judge almost jumped out of his chair and sustained my objection and instructed the jury to completely disregard any of the BAC evidence about time of driving. You just can't let these witnesses keep doing this. It's the labs do not stand for good and reliable science. They stand for helping the state convict criminal defendants, and they'll say anything to get there, in my humble opinion. Okay. Well, we just answered what is extrapolation. Okay. Oh, how do you deal with, okay, let's answer this one. How do you deal with extrapolation? Again, if Atticus Finch is still out there, tell me what D's is. Does anybody know what that is? How do you deal with the BAC and no extrapolation in voir dire? Ah, that's a good question. So in jury selection, which is voir dire, it's important to cover that. If you know that there's no extrapolation facts and the state will not be able to prove what the BAC was at the time of driving, there's some real good ways you can deal with that. The way that I deal with that is by, well, I've done it a couple different ways. One is by drawing on my flip chart. I write down time of driving, TOD, and then I put time of test. And then I'll put a hypothetical number of like a 0.12 at the time of test. And then I'll draw an arc between the time of test and time of driving, and I'll say, this is the number over here, and I'll draw a question mark under the time of driving. This is the number that they have to prove beyond a reasonable doubt. You cannot base your decision to convict a person based on this number over here. It's a pretty confusing concept for most jurors, and we spend about 10 minutes on it, and it eats up most of my time in voir dire, but it's extremely important because you can get a lot of jurors struck for cause that say that they won't require proof beyond a reasonable doubt of what the BAC was back at the time of driving, that they're going to base their decision on any number they hear, no matter when it was in time. And they'll say things like, well, that doesn't make sense. And they'll look at me like I'm crazy, and they'll say, you're always going to be higher at the time of driving. How could you not be higher at the time of driving? They don't understand that when people drink, your BAC level goes up, and then at some point you peak, and then you go down at a slower rate than you go up. But you can be rising with your BAC for up to 2 hours depending on the food in your stomach. If you have a full meal, if you've just eaten, that can slow the absorption time significantly. So I'll ask them after we deal with all the questions about and the crazy looks about how could you possibly say that they were lower at the time of driving. And then I'll ask them, I'll say, okay, my question is, is there anybody that will not require that proof beyond a reasonable doubt of what that BAC is back at the time of driving? And we have to ask it like 4 or 5 different times, but there are people that will raise their hand and they'll say, yep, if I hear it, any number that I hear that's over 0.08, I'm going to assume that they were above a 0.08 at the time of driving. And then those people are struck for cause because basically they're not following the law, which requires proof beyond a reasonable doubt of a person driving while intoxicated, not of a BAC at some other point in time down the road. Another way that I deal with that is I'll do it more physically, and I'll stand with my body, and I'll go to the left side, and I'll say, here I am having some food, and then I finish my last beer right here, and then I go right and I get in my car. And then I drive, and just a few minutes later, I get pulled over. And then I go all the way to the other end of the courtroom, and I say, and here's where they test me. And then I walk back all the way over to the time of driving, and I say, here's where they have to prove that I was a 0.08 or above, this point right here, not all the way over there. And that helps them visualize it a little bit more. The last trial we had a police officer, a former police officer on the jury. And that was beautiful because I knew that I could use the police officer to help educate the rest of the jury. The police officer has been through that and has done DWIs She knew about absorption and elimination, and she knew that you are not always going down, and she knew that you could also still be rising at the time that you're pulled over by the police. So it was a great way to educate the rest of the jury. They heard it straight from a police officer's mouth, said, nope, doesn't mean that you're always going to be higher at the time of driving. So we ended up actually leaving that police officer on the jury. She was an ex-police officer and was only at the department for about 8 months. So, and then she went to work for Chase Bank. So we thought that she would be a pretty good gamble. There's some backstory there that she wasn't a police officer anymore. Normally we wouldn't leave police officers on the jury, even though I've done it before and they've become foremen and we've won. But anytime you have a police officer on the jury, it can be a great source of education for the rest of the panel if you've got some issue like that you need to flesh out. Okay. Oh, and sometimes too on that extrapolation issue, if you have a good judge and they see that the jury's not getting it, they'll step in and take over your voir dire for you. And that's, to me, that's completely fine. Some attorneys might think that they don't want a judge stepping on their toes, but then you have the judge educating the jury that they have to require proof of a BAC of a .08 or higher at the time of driving. And the judge is educating them for you. And it's twice as powerful as anything that you could do as the attorney, to have the person sitting up higher than everybody else in the black robe with their name on the front, telling them they have to require that. It doesn't get more powerful than that. And if you can, if you ever get that situation, it's very nice and it should be welcomed. All right, I don't think we're going to make it through all top 10, but maybe we'll do 5 this time and do 5 next time. Let's see. There was one I did want to answer. Maybe this is how do you feel about adding ABCs as one of the SFSTs? Maybe that's what Atticus is asking about. This is a really good point, because in this case we tried this week, I was representing an attorney, and when he was asked to say his ABCs, the officer said, but I'm going to modify it. And he even admitted on the stand that he wanted to make it unnatural. But the whole point is we're trying to figure out what a person's normal mental and physical faculties are, and we're using an unnormal test. He said, you're not going to do ABCs, and you're not allowed to sing them. You're going to start at K and go through X. But don't say K and don't say X. Ready, go. In voir dire, I talked to jurors about, if I asked you if you could say your ABCs right now, is there anybody here that would say they could not do that? And then I put them in the situation of being out on the side of the road, visually, ask them to visually picture themselves out on the side of the road where there's red and blue lights behind them. It's at night. There's an officer standing there with a gun on his belt, and they know that they're under investigation and potentially could be going to jail. And I asked them to try to picture what that would do to their pulse and their anxiety level. And then I asked them, now, thinking about your ABCs, what if they told you you couldn't sing them? I say, you would be surprised how many educated people would have trouble saying their ABCs in an environment such as that, just straight through from A to Z. But then I say, what if I told you, on top of that, you got to start at K and go through X, and you can't sing anything before K, and you have to stop at X, but don't say K or X, and then you say go. And the response that you get is, I can see where that would be difficult, and that's what we had in this case. So it's basically, there is no science that backs up the ABC test as being, it's not validated by any of the 3 studies used by NHTSA. It's an alternative test that is mentioned in the NHTSA manual that an officer can use. But you know what? Almost every single case I've seen, even cases where my clients have been under the legal limit and the cases have been dismissed, they have messed up saying their ABCs. It is not as easy of a thing to do as you think, and don't assume that it is. But it's like you're taking a very easy test and then you're saying, let's make it as difficult as we possibly can. Let's try to trip these people up, because if we can make them look dumb saying their ABCs, if we can make them stumble saying their ABCs, there's no jury that's going to think that person is sober. But surprisingly, it's very difficult, and I know this because I've seen it on hundreds and hundreds of videos, but it's something that you would never even give a second thought to. So I don't think it's a very good predictor of an impaired versus an unimpaired driver, and there's no studies to back that up, so it could not be added to the standardized field sobriety test at this point. Anyway, thank you for tuning in today. Looks like we've had a few viewers, and even got a question from a new viewer. So we're going to try to do this every Friday at 2 o'clock, and we will go on longer if there are more questions from you. So if you're a person dealing with the DWI yourself and you want some free time to ask some questions, even if you've already got an attorney, you know, I'm here to answer whatever questions you have about DWI, intoxication assault, intoxication manslaughter. If you're an attorney that's got a question, feel free to tune in on Fridays. You can also email us your questions beforehand, and we will answer them on this live web chat, okay? So this is called Ask the Expert, but it's really just an information session where we answer questions about DWI, and then it will be posted on YouTube later that you can search. My name is Tyler Flood, Houston, Texas DWI defense attorney. You can email us your questions or contact us anytime using office@tylerflood.com, or you can always call us at 713-224-5529. If you liked what we did today, send us an email or like it on Facebook. Thank you very much. Tune it out till next week.